BAC. You also have potentially ethical standards and guidelines which guide the behavior of arbitrators. And tonight, one thing I will do, at least briefly and from time to time, is talk about the International Bar Association guidelines on conflict of interest. There's also an earlier set of rules of ethics from 1987, but you don't hear very much about them because they're very broad and very kind of vague. But the IBA guidelines have the potential to be an important tool, and you may want to be aware of them. Let me also mention that for those of you who are aspiring arbitration lawyers or international lawyers, I think the International Bar Association is an excellent organization, and I would encourage you to be involved. Of course, we'll also talk about national laws and to some extent, international conventions. Now, I want to start by showing you a chart. And this is focusing in the international arena. I've listed a number of arbitration rules that might be incorporated in the party's contract. I've also noted arbitration laws. And we know that the law that applies in the arbitration and that might control in situations involving arbitrator disclosure and challenge of arbitrators for conflict of interest will often be the law of the seat. That is, the law where the arbitration is located, at least for legal purposes, the seat of the arbitration. Or potentially the parties are using the law of some other state, domestic law or international law of that state. And then you have so-called soft law guidelines, including what we might term ethical rules. And the IBA guidelines on conflicts of interest in international arbitration are a fascinating document. And I think will have a larger and larger impact as we go along. I want to talk tonight a little bit about the United States because the U.S. has a lot of law and extensive experience with arbitrator selection, disclosure, and challenge. I have to tell you that both as an arbitrator and a scholar, I probably spent as much time focusing on these issues as any issues in arbitration. So, for example, in the United States, if we're in a domestic situation where you're using the national law, we'd probably use the American Arbitration Association commercial rules. There is an international analog to those rules, which are the so-called Icdr rules, which we'll talk about a little bit later. These compare to CTAX rules or BAC rules for international or domestic application. Then you have arbitration laws. Now, the United States is a maddening place when it comes to trying to figure out what law applies because, as you probably know, we have a federal system, which means you have national laws, federal laws that are passed by our Congress. But we also have state laws. Every state has its own set of laws. And when it comes to arbitration, you have laws on both levels. And in fact, in a state like California, it gets even more complicated because we have separate laws for domestic and international arbitration within California. And sometimes it gets more complicated than that. Tonight, I'm just going to talk about our Federal Arbitration Act, the FAA. And I'm going to talk about what happens when someone fails to make a disclosure. Interestingly, in the United States, there are very few states that address disclosures, or very few states where courts get involved with disclosure issues before the rendition of an award. So usually what you're talking about is a situation where someone challenges or seeks to annul an arbitration award because there was partiality or corruption on the part of an arbitrator. This is Section 10B of the FAA. There is a whole body of case law in the United States which talks about situations where where arbitrators fail to disclose connections to the parties or to the attorneys or to witnesses in the arbitration. And this then becomes the basis for someone trying to annul or vacate, as we say in the US, an arbitration award. I'll come back and talk a little bit more about that later, just for purposes of comparison. I know that you're very busy right now modifying arbitration law in China. I'm not even going to try to venture to touch on that, although I can certainly talk with you and learn from you in that regard. But I'm going to talk primarily about international situations and also a little bit about US-based cases. Also in the United States, we have several codes of ethics, the main one being one that was developed by the American Arbitration Association and our American Bar Association, which is the large national organization of lawyers. Other groups also participate. The Code of Ethics was developed back many years ago, but it was updated in 2004. And so we do have a pretty extensive Code of Ethics. And what is this about? It's aimed at trying to guide arbitrators and the activity of arbitrators. So notice that we have three different kinds of standards here. And I want to try to keep coming back to each of these in different settings. I'm going to throw a lot of information at you, but I hope you find this useful. And eventually, of course, you can go back and look at the slideshow later. You know, I could ask why disclosure by arbitrators is so important. I ask my students this and groups of lawyers that I worked with. You know, the fact is, disclosure is so important. That is, disclosure of potential conflicts of interest by arbitrators is critical because of the nature of arbitration. Theoretically, when we are arbitrating, we're in a system of impartial justice. Now, on the one hand, we say that it should be fair. In fact, very often in American law, we talk about fundamental fairness. We say it may not look just like what happens in a court. No, it doesn't have to be exactly like court, but it needs to be fundamentally fair. What does that mean? So you have that issue on the one hand. On the other hand, we have this question about party autonomy and the ability of parties to pick their own arbitrators, their own decision makers. Now, there's a tension between this whole idea of, well, what is fair? What is impartiality and independence, and how far should you take that? And then on the other hand, how much choice should parties have? And how much autonomy should they have in choosing whomever they want as an arbitrator? Well, the fact is, most arbitrators, the great overwhelming majority, come from professional ranks. In most places, they tend to be lawyers, or in the United States and some other places, retired judges. Or they may be, in some cases, people with business backgrounds or other technical or professional backgrounds. So immediately, you're looking at people that come from a network of relationships. They come from, like in my case, I come from a construction law background. I specialized in complex construction and engineering disputes. And I continue to apply this specialty along with other kinds of commercial cases. Well, I know hundreds, probably more than 1,000 internationally, uh, people who are construction or commercial arbitrators or arbitration advocates. And I know just about as many people who mediate. And I'm constantly running into people that I know, that I have worked with or have served on committees with or whatever. A lot of people know me, and I know a lot of people. Now, the question is, when I become an arbitrator, what do I need to disclose? What's important? So this is a question that comes up all the time, because as some of you who are in attendance tonight, I'm sure experience, people on one or both sides may know you as an arbitrator. And the question is, how do you deal with that reality? Finally, arbitrators tend to have largely unsupervised authority in rendering awards. They really don't have a lot of accountability. There are major practical and legal limitations to overturning awards. So this is why disclosure up front and continuing through arbitration by the arbitrators of potential conflict of interest, of connections to the parties, the attorneys, witnesses, other arbitrators, should be disclosed and should be disclosed on a continuing basis. Now, of course, what makes this so complicated is often arbitrators are or were members of law firms or other organizations, and people in their law firm may have connections. People in their family may have connections. My daughter is also a construction lawyer. She knows a lot of people in our industry. Not as many as I do because she's much younger, but nevertheless, I have to disclose the fact that I have a daughter who does this kind of work. Some people may want to ask more questions about that. So these are all things that are important to be aware of. Disclosure resolves to some extent these dilemmas because it's saying to the parties, okay, we're going to give you the critical information you need to hear about all of these connections from the arbitrators. The arbitrators, or the would-be arbitrators, are saying, we're going to tell you a lot about our connections to the lawyers, maybe to the parties, and other connections. It's up to you to decide whether you want us to serve in your case. You may decide the connections are too close or you're uncomfortable with them. But this is the way the system works. So I'm going to just talk briefly and come back to arbitrator selection and disclosure challenges in the U.S. and the Icdr rules. Here you have, let's assume you've got a situation like this. You're in international arbitration proceeding. Oh, before I go into this, I should mention that I have served with AAA, the American Arbitration Association, under various rules, as well as a number of other organizations, and I'm a member of a couple of Chinese commissions as well. I am currently affiliated with an organization called JAMS. Now, we're not going to talk about JAMS in these examples tonight, but if anyone is interested, you can certainly look JAMS, J-A-M-S, up on the internet and find rules and various other sources of information about JAMS. AAA and JAMS are the two largest dispute resolution organizations sponsoring arbitration that are headquartered in the U.S. But this problem is about the AAA's International Center for Dispute Resolution, or Icdr. You represent a party in international arbitration proceedings in New York under the Icdr rules. The parties have selected arbitrators, and they've been in the midst of preparations for hearings. Now, let's think about what happens in each of the following separate scenarios. Maybe the arbitrator appointed by the other party revealed a current business relationship with a key witness for the other party. Very interesting. By the way, I want to make sure that all of our students in particular are aware of the kind of scenario I'm talking about. What I'm referring to here in this problem is a tripartite arbitration scenario where you have each party unilaterally choose an arbitrator. And these two arbitrators or the parties themselves will pick a chair for the arbitration panel. But you will have wing arbitrators that are appointed by each of the individual parties. Now, as a beginning proposition, certainly under the International Center for Dispute Resolution rules, all arbitrators, no matter how appointed, are supposed to be independent and impartial. Independent and impartial. But you have the reality that each side has picked one of the arbitrators. So here we have a situation where you find out let's say a lawyer for a party on one side, you find out that the arbitrator appointed by the other party has certain connections with a key witness for the other party. Now, this is something that you may want to do something about because you're concerned about it. Or you may find out you have a situation where the chair is representing a party in another arbitration involving similar legal issues and is taking a position in a case contrary to your client's position. Boy, that's concerning, isn't it? And finally, maybe the chair of the panel has ruled that certain evidence favorable to your client will not be considered. And your client says, I want to remove this arbitrator. Well, the appropriate measure, typically the appropriate measure in a situation like this, and certainly this is what the Icdr rules call for, is a challenge that is submitted to the Icdr itself, an administrative challenge. Now, there are different, as we will see, there are different kinds of challenge procedures. In some circumstances, a challenge must be mounted under the Uncentral rules, for example, must be mounted initially to the arbitration panel. So the fact is that there are different approaches, but under the US Icdr rules, the approach will be that you'll go to Icdr and you'll say, I have a problem. I want to find out, first of all, I may want to find out more about this business relationship with a key witness, but I may want to object to this arbitrator sitting on our case. So question is, what standards govern in a scenario like this? And we will explore this. Likewise, although it sounds like a more difficult proposition to raise an issue, question 2 here, or example 2, raises some issues that might make people uncomfortable. They might try to raise a challenge to the chair sitting in the arbitration when the chair is taking a position in another case that is contrary to the client's position, because that does seem to raise a conflict of interest. Then, of course, you have situations where a chair has made a ruling that was unfavorable to a client. We know that normally that is not, in and of itself, a basis for getting rid of an arbitrator, successfully challenging an arbitrator. It's not. Although in certain circumstances where it is suspicious and where you have surrounding circumstances that might indicate a lack of impartiality and a lack of independence on the part of the arbitrator, that might be relevant that the arbitrator is taking such action. So we actually have different kinds of rules. And again, primarily focusing on our students, you should always be thinking about several things. when you look at rules in the area of arbitrator selection, disclosure of conflicts, and challenges. First question is, and this may seem silly, but in the United States, frankly, it's important. And that is, you want to look and see if in the rules it says arbitrators must be independent and impartial. Now, maybe this doesn't seem like a controversial issue to you. And in fact, in most cases in the United States, arbitrators are expected to be independent and impartial. And certainly in virtually every situation I'm familiar with, the chair is expected to be independent and impartial. Interestingly, in the US, and I won't dwell on this at length, I won't spend a lot of time focusing on it. In the US, we actually have some kinds of arbitration where the parties, arbitrators, that is, the arbitrators appointed unilaterally by the parties, may be somewhat partisan, maybe a lot partisan, that is leaning toward or favoring the party that appointed them. Now, that may seem outrageous. It is not the law in a lot of countries, but it is a practice that for some reason developed in certain kinds of commercial cases in the United States. And to some extent in the reinsurance realm internationally. Isn't that interesting? We're not going to dwell on that tonight. We're going to operate on the assumption that we're dealing with independent and impartial operators, although I'm glad to talk about that later. But here in the Icdr rules, you have a rule that says arbitrators have to be independent and impartial. You have another rule that says if you have an issue with an arbitrator and the disclosures by an arbitrator, and by the way, that's another rule that one should be aware of, disclosure rules for arbitrators, because arbitrators have to make broad disclosures about connections to the parties, to the lawyers, or to the case that may give rise to reasonable suspicions that they are not neutral, they are not independent and impartial. So not only do they have to be independent and impartial, they have to make disclosures about connections to the case. Article 14 says that parties who have an issue with respect to something that's been raised may raise a challenge, an administrative challenge with Icdr. And Article 15 says an arbitrator may be replaced upon challenge. Again, this is exemplary of what many organizations do. You have an administrative procedure of some kind to decide whether or not a challenge to an arbitrator should be effective. One of my American friends, who's an international arbitrator, likes to say that when you challenge an arbitrator, they're going to find out, of course, that someone is challenging you and probably who challenged them, and you better hope that you win the challenge. It's a little bit like, as my friend puts it, murdering the king. If you don't kill the king, you may be in big trouble. So if you don't win a challenge against an arbitrator, it may be very dicey, as we say. It may create difficulties for you during the course of the hearing. In any case, then we'll come back and talk more about some other issues later. So under the Icdr rules, it says a party may challenge an arbitrator whenever circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. One thing you often see in arbitration rules is what we sometimes refer to as an objective standard, a rule of reasonableness. Are there justifiable doubts? Would a reasonable person have doubts about the arbitrator's impartiality or independence? In any case like that, a party may challenge the arbitrator. Now, what are some bases or challenge? How do you decide when a challenge should be effective and you should remove an arbitrator? Well, there's one, although this hasn't been talked about as much as I would like in a systematic way, there is one Icdr case, that is an international uh, um, investment dispute resolution center in Washington, D.C. There's an Icdr case that actually talks about these kinds of things. It looks at a challenge to a sitting arbitrator. And they said, there are certain aspects that you want to consider when you're thinking about whether a challenge should be successful. The proximity of the arbitrator to the case or to a party or to a lawyer or some other person associated with the case. How closely are they connected? What's the intensity of the relationship? Are they part of an organization of 400 people and they see each other once a year and say hello? Or are they business partners and working together on an ongoing basis? Just what kind of connection are we talking about here? How intense is it? What is the dependence of the arbitrator on the party? For example, is the arbitrator doing work for or with a party? And does the arbitrator depend extensively on that work? Is it important to the arbitrator? So this is yet another way of looking at the evidence. And finally, materiality. To what extent is this likely to have an impact on decision making by an arbitrator? Now, you may never have seen this Icdr decision. If you want, I can try to provide you with a citation to it. But I will tell you that I thought it was very helpful to think about these aspects of the connection as a basis for deciding whether a challenge should be granted. And then there are also the IBA guidelines on conflict of interest in international arbitration. I don't know if you can see this as I hold it up. You can find these pamphlets online. They're pretty extensive. And essentially what they do is to serve as a set of standards, and they might be used in many different ways. They're what we call soft law standards. Soft law standards are standards that are not necessarily legal standards. They are not necessarily binding from a legal standpoint, like a law. However, they may be adopted by the parties as an operative standard in a case. They may be relied upon potentially by decision makers in some cases, particularly if an institution has adopted them or embraced them. So they're important to be aware of. There are lots of different kinds of soft law standards. I think the IBA guidelines on conflicts of interest are important for anyone who is involved with international arbitration because they are a true international standard, although they are a soft law standard. They may be influential. There are actually 4 parts of the guidelines on the conflicts of interest. And essentially, if you look at the guidelines, and maybe a number of you are familiar with them, I would encourage you to go through them and actually read them in detail. We don't have time tonight. One of the things you should be aware of is that there are 4 categories of situations. And what the authors of the IBA guidelines did was to say, let's create these standards. Let's create 4 categories of situations. And let's take potential conflicts of interest, relationships, other realities, connections to a case or to the issues in the case. Let's put all of these different kinds of scenarios in one of these four categories. There are three different colors and four categories. Two of the categories are in the red area. Now, before we talk about them, I'm going to start at the other end. I want to talk to you about the green list. There are a lot of situations in which you may have a connection to a party or to a lawyer or to a witness or some other kind of connection that might, in some circumstances, be a conflict of interest, might be disclosable, or you should disclose it. If it's on the green category, however, the green list, it does not have to be disclosed. Now, this might be a connection you had with someone that is distant in time. It's more than a few years old. Might be a situation where, you're both part of a large organization and, really have minimal contact. All of these factors suggest that it's just not that important. And if you don't disclose it, it's not a big deal. Some arbitrators might still say, well, I'm going to err on the side of disclosure. But the standard is saying, there are some situations where it's just the costs, transaction costs associated with it are greater than any benefit that might come out of it. Then there is the stuff on the other end, the red categories. Now, these are the sorts of scenarios where you better make a disclosure. You need to make a disclosure, and there is no ifs, ands, or buts about that. It's divided into two parts, and this is very interesting. Let's say you have a situation where you have represented one of the parties recently, maybe within the last 3-4 years, whatever. It might say, and I'm not looking at the IBA guidelines, so I may not be right about the timing, but let's assume it's something that you should disclose. Now, often, if someone makes a disclosure, you can waive any right to object. You could say, oh yeah, I know that you used to be in law practice with the other party. And I'm going to say that's okay because you and I have also known each other for a long time. I'm going to waive the right to make an objection to you as my arbitrator. So that's the way a lot of the items on the red list are. You can waive your right to object. And in fact, one of the issues you've got as an arbitrator, as a lawyer in arbitration, is that if you don't make an objection within a certain period of time, the arbitration rules may prevent you from raising the objection after a certain period of time. And frankly, you may be prohibited from later raising a motion to vacate the award because you didn't make a timely objection. So you need to be aware, waiver is a very important thing, and you want to avoid it if you need to raise an issue. However, there are certain kinds of scenarios where the International Bar Association says you can't waive an objection to it, meaning you simply can't have a certain kind of situation. You can't have one of the parties serve as arbitrator. You can't have the current lawyer, the general counsel of a party, serve as the arbitrator. This group of international arbitrators says that's not arbitration. Let's not even permit waivers of objections to that. You can always object in a situation like that. Finally, you have the orange list. Now, this is kind of frustrating because the orange list is the in-between list. These are situations that, depending on the circumstances, might have to be disclosed. So you're probably going to want to err on the side of disclosure, even though there may not be an absolute requirement that they have to be disclosed. You have the option, at least under the list. Now, let's say you are being considered as an arbitrator. I'm going to stick with the U.S. standards for a moment, with your permission. Let's assume you're currently representing one of the parties in a separate legal matter. Or 2 years ago, a member of your law firm gave limited advice to one of the parties on a separate matter not relating in any way to the present case. And finally, you're a member of an IBA committee with a lawyer for one party. Now, what you'll find is that often a lot of arbitrators will feel that they are ethically bound to make broad disclosures. I tend to be on that side. I would probably disclose all of these connections. However, I have to say that the only one that I think would probably be seriously problematic as a matter of a conflict of interest would be number one. Number two is more in between. Again, it's another member of our law firm. Very limited advice. It was a couple of years ago. But then a member of an IBA committee. I suppose you'd want to know more information about that. Is this a committee you both have been on for 20 years? And you attend all the meetings and you are close friends as well. Clearly, that changes the whole complexion of the issue. So as you see, there are a number of different potential outcomes depending on these different factors and the proximity, the intensity, the materiality, etc., of the connection. Then we have some other ethical standards in the United States. These are separate from the IBA guidelines. These are U.S. specific, and I'm just using them as an example. Let me say to our students, when you are an arbitrator, or when you have been asked to be an arbitrator, the first thing that happens when you are invited to be an arbitrator is something that happens inside you. It's not a matter of even yet of the rules of the Arbitration Association or law, although they might be in the background of your decision. But as a U.S. arbitrator, I usually am applying a code of ethics for arbitrators. And the first thing I have to decide for myself is, am I ethically able to accept appointment as an arbitrator? Well, I should accept appointment as an arbitrator only if I am fully satisfied that I can do four things. That I can serve impartially, that I can serve independently from the parties, potential witnesses, and other arbitrators, that I am competent to serve, that is, I believe that I'm enough of a subject matter expert or a process expert or both that I feel comfortable being involved. And finally, am I available or am I too busy? That's a big one in international arbitration. Often you get very busy people who, frankly, probably shouldn't take some of the cases that they do. But parties want them, they're popular, and they go ahead and accept the case, and the case drags on because they're so busy. So I'm not going to spend time getting into the details of this. But just as an example of an ethical code, you might take a look at Canon 1 of the Code of Ethics for Arbitrators in Commercial Disputes. This may actually come into play in an international arbitration if you're operating under the Icdr rules. It says, you should avoid entering into any further business, personal, or professional relationships likely to affect impartiality, or which might reasonably create the appearance of impartiality. You're also required under Canon 2 to make disclosures. And I'll just look at part of this. You must disclose any known direct or indirect financial or personal interest in the outcome, any known existing or past financial, business, professional, or personal relationships which might reasonably, there's that word again, reasonably affect impartiality or lack of independence in the eyes of any of the parties. And it goes on. It also says you should disclose connections that members of your family or your law partners or your employer or your associates have. That makes things quite a bit more complicated for some people. And you need to disclose a few other things here, which you're required to disclose under the law or institutional rules. You should make a reasonable effort to inform yourself of interests or relationships. There's an obligation to inform that's continuing throughout arbitration, and any doubt, ethically, any doubt should be resolved in favor of disclosure. And the disclosure ethically is supposed to be to everybody, to the parties and to the other arbitrators. Now, what it says here is that if you are going as far as to disclose something, this means you've already made a determination under Canon 1 that you can serve. You believe that you can be independent and impartial. However, there's another step, and that is that you have to tell people about your connections so that they may raise an issue if they want to and potentially seek to challenge you. And I'm going to skip on and go to the next hypothetical. Before we go into this hypothetical, though, which is actually under international rules, I'd like to invite any questions that may have come up in the material that I've covered so far. Maybe I can take 1 or 2 or 3 questions. Anybody have a question they would like to ask? If not, keep track of your questions and I will go ahead. I cannot see all of you, so I'm not able to see if you have your mechanical hand up. Weigao, are there any questions at this point?
I can't see any questions right now.
Okay. Then we will continue, and I will save time at the end for questions and conversation, because I want everyone to be able to discuss what they wish. Okay, you represent Turnkey International, which is a general contractor in an arbitration involving a major construction dispute associated with a private company, Kardashian Development Corporation, in the Republic of Kardassia. This, of course, is a fictional country. Kardashian Development retained Turnkey to build the Northwest Kardassia International Airport in Kingsmere, Kardassia. The contract contained an arbitration provision which provides for arbitration under the Uncentral Arbitration Rules with the ICC as appointing authority, the International Chamber of Commerce. The provision calls for Kardassia to be the seat of arbitration. Kardassia has adopted the model law on international commercial arbitration. Now, the model law is the law in more than 60 different countries around the world. It is not the basis of the arbitration law of China, nor is it the basis of the arbitration law in the United States. Although interestingly, it is the basis of arbitration law in some U.S. states, individual states. Anyway, here the contract provides for Kardashian law to be applied in interpreting the contract. In accordance with a provision in the contract, Turnkey and KDC each unilaterally appointed an arbitrator, and those two arbitrators picked a third arbitrator as chair. Now, assume the parties have just announced their list of witnesses for the hearing, and you have heard from two different sources that one of the key expert witnesses for KDC, that is, they'd be an expert of the owner, KDC, they have recently done extensive consulting work with the arbitrator selected by KDC, and have also worked, and that this key expert witness has also worked as a consultant to the chair of the arbitration panel and his law firm. Neither the arbitrator appointed by KDC nor the chair has thus far made disclosures regarding the matter, but you are very, very concerned about those arbitrators' ability to render an impartial decision under the circumstances. So we assume arbitration hearings are to begin soon in Kardashian. Now, what are your courses of action? Should you go to court? Should you ask the two arbitrators to resign? Should you tell the arbitrator you appointed to resign in protest, or appeal to the entire panel for relief through majority decision, or something else? Well, the answer is it depends. But what it depends on often is, first and foremost, is what does your agreement provide? Now here we have the parties who have an arbitration agreement that incorporates the Uncentral, the UN Commercial and Trade Organization, its rules of arbitration. And these are widely used around the world. So those would be the rules I would want to look at first. So I would probably also want to be aware of the model law, because the model law is the law of the country in which the arbitration is taking place. So normally you would not necessarily go to a court for relief initially. But again, it depends on the circumstances. You probably would not ask the two arbitrators to resign, but probably take another approach. You probably would not tell the arbitrator you appointed to resign in protest. That creates a number of problems. Might you appeal to the entire panel for relief through a majority decision? Maybe, depending on the rules you're operating on, or something else. Well, in this particular case, we have the Uncentral Arbitration Rules, and I want to talk first about those. The Uncentral Arbitration Rules, Article 11, establish an ongoing obligation of all arbitrators to disclose any circumstances likely to give rise to justifiable doubts as to their impartiality or independence. There's that word again, justifiable doubts. So the arbitrators should have made this disclosure. Now, they didn't, which in and of itself would be troublesome to me if I'm on the other side. So under the Uniform Arbitration Rules, the next article, Article 12, it says, if circumstances exist that gives rise to justifiable doubts as to their impartiality and independence, you may challenge them. You may challenge them. So in this particular case, you can, under the Uncentral Arbitration Rules, Article 13, you would begin the challenge by actually sending a statement of reasons for challenge directly to the tribunal. Why is that? Well, because the Uncentral Rules are not like the CTAC rules, not like the ICC rules, not like many other rules. Why? Because there's no generally administering organization. They assume that for many respects, the arbitration's not going to be administered. So what happens? You go to the tribunal. Now, you can ask them to withdraw. After you've made this challenge, if they don't withdraw, then the arbitration tribunal is to decide the challenge. So the individual arbitrators do have a chance to resign. That is true. But if they don't, then the arbitration tribunal as a whole must make the decision. Problem here is that the arbitration tribunal in this case is comprised of three people, two of whom are challenged. That's an issue for me. So fortunately, the Uncentral arbitration rules allow another step. They allow you to go to the appointing authority, if there is one. Here, the appointing authority, meaning the administrative body that appointed the arbitrators, is the ICC. So you'd go to the ICC and you'd say, we want to challenge these people. They won't step down. The tribunal has refused to cause them to step down. Now we're asking you, the ICC. So that's an important consideration. So that's the way it would happen. It would go to the ICC court for a final decision. So the under 3.4.3 of the IBA guideline on conflicts of interest, we look at that. It's 3.4.3 says a close personal friendship exists between an arbitrator and a manager or director, or an entity has a direct economic interest in the award to be rendered in the arbitration, has a connection with an arbitrator or manager, or any person having a controlling influence, such as a controlling shareholder interest on one of the parties or affiliate of one of the parties, or a witness or expert. So if you have that kind of scenario, potentially, you might be dealing with a situation where it certainly needed to be disclosed. It's in the orange range. The more, now if someone, the arbitrator, has within the past 3 years served as counsel or is serving as counsel currently, that falls within the orange list, or excuse me, if it's within the past. If it's a current legal relationship, that falls on the red list. So again, if you look at the IBA guidelines, it might give you some sense of just how serious this is. So again, it depends on the rules that you're operating under, exactly how things are going to be handled here. We can also talk later about the impact of arbitration law. Let's go ahead and think about this. What difference, if any, would it make if you did not discover these relationships, and also you never found out about it. It was never disclosed by the arbitrators until after the award was rendered, and the award was adverse to your party, the contractor. Could you sue the contractors? Could you sue the appointing authority, or do something else? Now, I'm not going to spend a lot of time talking about liability waiver here. There are provisions in the Uncentral arbitration rules. They are also in the ICC rules, and many other institutional rules say you have waived, by entering into these rules, you have waived any right to sue, or at least to hold us liable, to hold the arbitrators liable, or in some cases to hold the institution liable. The question is, what law applies? As you know, there are big differences among countries, among states, as to how they look at arbitrator liability. In the United States and in some other common law countries, arbitrators are viewed as quasi-judicial persons. They are like judges. That's the way we think of them and the way they think of us. So, in other words, I'm given quasi-judicial immunity within the scope of my arbitration role. So that protects me, and it typically protects the institutional body that is supporting the arbitration. However, in many civil law countries, as you know, more of a contractual approach is taken, not looking at arbitrators as judges, but more like people rendering services under a contract. They're negligent if they fail to conform to the obligations of their contract. They may be liable. So again, this is a basis for being aware of these sorts of situations. So the liability waiver may or may not come into play. Now, the question is, what happens when an award is rendered? Are there possible grounds for setting aside the arbitration award in the courts of the seat? That is, if you took this award, which, by the way, is in favor of a Kardashian entity, to the courts of Kardassia, assuming you want to do that, are there possible grounds for setting aside an award? Well, we know that Kardassia has the Model Act, which provides a basis for setting aside an award. And Article 34, subsection 2 says, where the composition of an arbitration tribunal or a procedure was not in accordance with the agreement, the award may be set aside unless such agreement was in conflict with a provision of law from which parties cannot derogate. So do be aware of that. There may be an opportunity here to get an award vacated because of these connections. So do be aware that there is at least some possibility. Likewise, if you go to another country, you may seek recognition and enforcement in a place where the losing party has funds or assets that you want to try to attack, to get hold of in satisfaction of the award. So you want to get the award recognized and enforced in another place. So you go to this other country. Well, maybe they have the model law too. And then you'd end up with a similar situation. Of course, they might interpret it differently in the courts, but nevertheless, there's a possibility that you might, after the award, be able to vacate the award or prevent recognition and enforcement of the award under the New York Convention or the model law, if they have that in that country. Now, so we've talked about some of the different standards. Look at all the different standards that might apply with respect to exclusion of liability, and then think about the issues relating to enforcement of an award. Uncentral Model Law 34, New York Convention Article 5, etc. Okay, let's take one more example from the United States. I'm just about to a stopping point, then I'm going to invite questions from the audience. Let's say, suppose instead that Turnkey International, a company headquartered in Cartusia, has a contract with Diamond Corporation for the construction of a project in the US. The seat of the arbitration is in Chicago. The Icdr rules have been incorporated in the construction contract. Again, assume the parties have just announced their list of witnesses, and you've heard from two different sources that one of the key expert witnesses for Diamond, that is an expert witness of the owner, has recently done extensive consulting work with the arbitrator selected by Diamond, as well as the chair and his law firm. Neither has, it's just exactly the same problem, but we're in the United States. Well, so now we're under these International Center for Dispute Resolution rules, let's assume, and you're dealing with Articles 13 and 14. So you have a similar situation, except that the administrative procedure is different. Under the Icdr rules, you go right to the administering organization, typically, and the Icdr itself will make a determination on whether or not the challenge should be recognized against these arbitrators and remove them. Now, as I mentioned, if we get to the end, after the end of the, oh, and by the way, let me just mention that in the United States, courts do not typically get involved in matters of disclosure, in matters of conflict of interest, not normally, prior to the rendition of an arbitration award. The FAA doesn't say anything about that, but the award may be challenged for evident partiality or corruption of the arbitrators. So let's look at this last part. What difference would it make if you find out about this connection or these connections after the award is rendered? It's a similar kind of scenario, except we're not applying the model law now. We're applying U.S. law. If we're looking to get the award enforced in the United States, which is the seat of the arbitration. Now, we have a very interesting history, which I won't dwell on here, except to say that we have a provision of FAA Section 10, which is the section on vacatur, which is the same as setting aside an award. You can set aside an award or vacate an award if there is evident partiality or corruption in the arbitrators or any of them. We had a case some years ago called Commonwealth Coatings. Let me see if I have. I'm going to just skip on here and show you FAA Section 10. And Commonwealth Coatings was a case in which an arbitrator, actually the chair of the arbitration panel, failed to reveal a very recent important business connection with one of the parties. And the Supreme Court said, we are going to direct that this award be vacated, it be set aside. Why? Because there was a non-disclosure of a certain connection. They said failure to disclose certain relationships or facts may itself be enough to vacate an award under the evident partiality standard. The mere fact that there was not a disclosure without proof of active partiality on the part of the arbitrator is enough. Just the fact that you did not make the disclosure is enough to vacate the award. Now, how important does the connection have to be? That's the issue. How important does the undisclosed connection have to be? Well, don't try to read all of the language on this page. Let me simply say that, interestingly, there were 4 justices who said, well, it doesn't have to be a lot. You have to make a disclosure whenever whatever it is you should be disclosing might create an impression of possible bias or even an appearance of bias, which sounds very, very low standard. Sounds like, gee, you might have to reveal almost everything, any kind of connection. But there were important votes from 2 judges who said wrong. It has to be, we agree with the result. We agree that there should have been disclosure here. But the reason there should have been disclosure is this was a very important, substantial relationship between an arbitrator and a party. If you look at cases today in the United States, this is one of the more recent ones, important ones from one of our appellate courts in the US, the positive software case. And basically, in positive software, they acknowledge that the vast majority of courts in the United States have said you have to meet that higher standard. It has to be a substantial relationship. It's not enough that somebody failed to disclose a connection that a partner of theirs had with somebody 10 years ago. It's ridiculous. That would be like the green category under the IBA guidelines. It said that's not something that should be a basis for vacating an award. Vacating an award is a big deal. So it should not be easily done. So it has to be some kind of important relationship. And so I will go on right now. I do have a section of the outline on what happens when there is a vacancy in the arbitration tribunal. The short answer is this, and then I'm going to conclude this lecture so that we can talk with each other. And I really welcome your questions. We had some great ones last year. What happens with respect to a vacancy? Well, it can be a real mess if you have a vacancy on the panel if you do not have rules that you have agreed to that deal with how you address vacancies. Fortunately, most arbitration institutions, as you probably know, have rules that deal with resignation or removal of arbitrators and vacancies that open up. And this explains how you would go about replacing an arbitrator, or if you will, or under what circumstances the other arbitrators, the other two usually, might go forward in the absence of a replacement. But it's important. This is one of the areas where you really, really do want to have rules, because if you don't, you can end up with some real problems when it comes to a vacancy on an arbitration tribunal. Okay, I'm going to stop the arbitration, this slideshow, and hopefully, yes, that opens back up the screen. So now I can look at all of you, and I want to welcome any of you who might like to raise a question either directly, or perhaps you can send a chat question through the professor. But I'm certainly happy. In fact, I would very much enjoy talking to you either about some of the issues that I raised tonight or about other issues that you'd like to talk about with regard to international or domestic arbitration.
Thomas?
Yes.
Thomas, I myself enjoy your presentation, the way you're presenting the materials, because to illustrate, you gave many examples, which I think is very helpful to understand the situation in the practice. This topic, the disclosure, is very important in the practice of international commercial arbitration. That's why we invite you to give lecture today. And many arbitrators are invited mention that the international arbitration is a club, right?
That's right.
It's closed club. And everybody, yes, everybody knows everybody. That's why there must be some mechanisms to address problems arising out of impartiality of arbitrator. So we can't wait until the award was made. It was too late. Even if there is some methods to go against the arbitral awards, but it is too late.
Yes.
Yes, and I have a question for you.
Okay.
Imagine a scenario we are both in the arbitration proceeding. You are the arbitrator and I'm the counsel of a party. And
Right.
we know each other already, right?
Yes.
So do you think there's a need to disclose the relationship between us in the case? And another, yes?
Okay, go ahead. Do
Yes,
you want me
and
to
what if,
respond?
what happened if you are the arbitrator and I am the student? I'm your student for many years, for instance.
Yes.
That's my
Yes.
question.
My practice is to make broad disclosures. And if I knew that if you were the lawyer for the party in this case, I would disclose the fact that we are we have been colleagues or friends, or you were my student or whatever. Generally speaking, I would disclose that. For one thing, I think that sometimes disclosures are actually helpful to an arbitrator because if I have connections with both parties, it's wonderful because it sort of makes me look important, doesn't it? In other words, it's like a credential. You know, you say, oh, he knows Professor Wei Gao, and then he knows the the lawyer on the other side, and goodness, he knows everybody. So 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 they say he must be a wonderful arbitrator, whatever. So that's one way to look at it. But the primary reason I do it is because I don't want to leave any stone unturned that will perhaps allow my award to be challenged. I don't want my award to be set aside. I want it to be enforced either in the country where it was rendered or internationally under the New York Convention or the model or under other laws. And so I think it's really critical. I try to do everything I can to prevent an award from being overturned, and that would be one thing. I did have an experience a couple of years ago where I was challenged by one party, and it was in an Asian country, and it was an Asian national arbitration institution. And one of the parties was represented by an international law firm, and the other, well, I guess they both were. But I had done some work 2 or 3 years ago for another branch of the international law firm, and the other party decided to challenge me. And I looked at the IBA rules, the guidelines, and I did not think that it was a basis for a challenge. And in fact, I talked to several of my very experienced arbitrator friends, and they all urged me to continue. They said the odds are very low that you're going to be removed from the panel. And I had one colleague who actually teaches ethics in international commercial arbitration and collects decisions of administrative panels on these issues. But after this went on for a while, there were letters going back and forth, and I finally decided to recuse myself. I stepped aside because I was worried that I could not be an effective chair if a party was feeling so strongly about my relationship, even though I didn't think technically they had grounds to remove me. I said ethically, I should step aside because I want the arbitration to be a success. So not everybody would do that. My friends said I made the wrong decision, but I think it was a right.
Thank you so much.
Hello.
Yes, Professor, I have a question.
Hi,
Can you hear me?
good to see you.
Hi.
Ni hao.
Hi. As to the range of disclosure, do you mean the wider is the better to avoid the disclosure risk? That's my question.
Yes, as a practical matter, to me, broad disclosure is the sensible approach, because it prevents your award from being in danger later. And I think it helps to clear the air, and in some cases may help credential the arbitrator. So for a variety of reasons, I do that, and most of the arbitrators that I talk to about this do that.
Okay, thank you.
Thank you. What other questions?
Hi, Professor. I have a question.
Of course.
Sorry, my dorm is a little bit untidy, so I'll just, yeah, sorry.
That's okay.
Okay, so
You should see my office.
It's worse, right?
Yeah, it's worse than your room, I'm sure.
So among those types of ethical standards, you mentioned a lot, say arbitration rules, arbitration laws, and ethical codes. What do you think, like, if they do have a conflict, so what is the main reference for arbitrators?
It depends on the timing of the issue, first of all. Depends on the timing. Now, remember that I said to you, if you are an arbitrator, you've been asked to serve in a case, I'm sure you would probably look at the rules under which you would be operating. I'm sure you would. But the first question will come up, at least in my case, it comes up under the ethics rules, because the code of ethics tells me I should not move forward. I shouldn't even accept the appointment, and I shouldn't even bother about disclosures unless I feel good about my ability to be independent, impartial, competent, and available. And if I can't, then I shouldn't move forward. So that's one time. Then if you're dealing with the issues during the course of arbitration, normally the first place you look is the arbitration rules. Sometimes the law may come into play. Like I mentioned to you that's why I gave you multiple examples, because it varies. What I'm telling you is you should always say, what are the standards that might be applicable? What are the arbitration rules? That's number one. What are the laws in the background that may come into play here? And finally, are there ethical standards that I'm supposed to follow as an arbitrator? So any or all of those may be involved, depending on the timing.
Thanks. And I have
Thank you.
another question. Yeah.
Okay.
So if I am kind of one party, so among all those factors, including reputation or expertise, common sense, this kind of thing, what do you think is the top desired qualification in choosing the arbitrator for parties?
What are you talking about? Arbitrator reputation and what contributes to that?
Here I mean, like, is this arbitrator independence and impartial, and this kind of I think this kind of things makes up to it his or her reputation.
Yes, I think, let me say, it's a little tricky. I agree that, a reputation for fairness is a very important thing. And to feel like someone is independent-minded, they are capable of independent decision-making, I think that's important. If we have any individuals with us tonight who do work in international arbitration, I will tell you that sometimes they do say that parties who are going to pick their arbitrator, where you're in a tripartite panel, if each side is picking an arbitrator, they often want an arbitrator that will perform a translation function. I don't mean translating Chinese to English or vice versa. What I mean is explaining to the other arbitrators the point of view of a culture or a legal tradition. So, for example, if you and I sat down and we talked at length about the way American law and lawyers look at contracts, and we compared that to the way Chinese business people and lawyers look at contracts, there might be some differences in the way we think about the way a contract functions. And that might have a big impact on decision making in a case. In fact, some years ago, I had a case involving an Asian party and a national government from the Middle East. And cultural perspectives were really important. And the panel talked a lot about cultural perspectives. So sometimes it's interesting. Sometimes you might get picked and they'd say, yes, we want you to be independent and impartial. But another reason they're picking you is because maybe you understand their culture. So maybe you can relate in some way to that. It's very subtle. That's very subtle. And what does that mean? Is that good or bad? Well, I think it can be okay. Usually you want someone to understand perspectives on contract, but it gets tricky because, again, there's a tension between awareness and this conceptual idea of fairness. I don't know if I explained that very well, but I think that's interesting.
Thanks. Really, thank you for your answer.
Well, thank you. I hope that was responsive. Are there any other questions? Do we have time for any others? I'm happy to, do you have another question that might not relate to disclosure or challenge or conflict of interest? Something about arbitration or dispute resolution? Okay.
Okay, I have another question, maybe the last question.
Okay.
Is there anything new relating to online dispute resolution in the US?
Anything new? Yes, there are. I think it may be international, and you may be aware of this, Wei Gao, but there are new standards that are coming out for online dispute resolution. And I will tell you that I'm using Zoom extensively right now. I have about 7 arbitrations in different stages, most of them just in the early stages, or in the US or in some international cases, they drag on because there's a lot of pre-hearing process. But there are a lot of opportunities to go online and talk. So I think things are developing very quickly. One thing that we're seeing is that a lot of, and I know this is happening in China too. I don't know all the details, but I know that many courts have pilot projects for online dispute resolution. And it's allowing people who may not have a lot of money or who may not, be able to drive 50 miles or 50 kilometers to a court. They can go online, they can go on their cell phone, and they can appear in a small claims court proceeding, or maybe a case involving a family issue. And so I think it's going to completely change the way we think about things over the next few years. It's already making big changes. And the pandemic, the COVID pandemic, I think has given us an opportunity. By the way, I just want to say I hope you all are well and continue to be. I hope no one here has to suffer with COVID. And I've been very fortunate, and my family has been very fortunate so long. But we are all united in our hope that things will get back to the way they were. And meanwhile, I do want to leave you with the idea that if you have any questions or you ever just want to contact me, you are welcome to, and your professor will be happy, I think, to pass on questions or to put you in touch with me. As I say, I really respect your law school as one of the leading institutions of its kind in the world. And I'm so privileged to be a part of it. And I really enjoy interacting with all of you.
Thank you, Thomas. We're honored to have you as our global faculty. And if there's no further question, I guess that will be all for today. Thank you all for participating, and thank you very much for giving the lecture, Thomas. We very much appreciate your participation. I do hope we can meet on campus next year.
All right. And Wei Gao, I know you and I will be talking soon. I look forward to it. And best wishes to all of you. Thank you again. Take care.
Thank you.
Bye-bye.